My name is Mark O'Brien. Some of you may have met with me. Some of you may seen my name on some of the packets before, or any of our marketing or promotional materials. I'm an estate administration attorney here. What that means is I handle probates, trust administrations, guardianships, conservatorships. I also have significant experience in estate planning, although that is not my main function here. At prior firms, I've done years of estate planning, some tax planning, some business entities and organization transactional work. But my main practice here is really navigating estate administration. What happens when someone becomes incapacitated or when someone passes away? And I've been doing estate administrations in some form or another for about 12 or 13 years. 12, yeah, about 12 or 13 years now. Just to give you a little background on myself, I've worked in Orange County, LA County, Ventura County, so quite a spread over Southern California. These are all the attorneys that we currently have employed at Copenbarger, and they're varying specialties. So you'll see we have estate planning attorneys, business and tax attorneys, estate administration, litigation. We are really a one-stop shop when it comes to all things estate planning, estate administration, estate litigation, and any of the tax, business, and transactional aspects that go along with any one of those specialties. This is a picture of our staff in general. This would also include paralegals, our legal assistants, our marketing, the accounting department, all of the people who make this firm run and operate the way that it does. We are very glad to have them and very appreciative for them. Some of our locations. I'm coming from the South Coast Metro. That's our main office here in Orange County. We have offices in San Jose, Temecula, Santa Cruz, Pasadena. Myself and some of the other attorneys I mainly meet with people in person at the South Coast Metro. However, I do a lot of Zoom meetings, and when possible, and if feasible, we try to meet with clients, at the office closest to them. So a lot of times I'll make appointments in Temecula or Pasadena, and the same goes for a lot of the other attorneys at this office. Okay, today's agenda. It looks like everyone that will be joining us has joined. So I'll go ahead and kind of start the substantive portion of this webinar, the reason why you are here today, right? So today's agenda, these are some of the main topics we're going to be talking about, right? Responsibility in grief, understanding trust, understanding probate, understanding kind of the differences between a trust and probate and sometimes how they coincide, key documents for both of those topics, some common pitfalls, things to be looking out for, things to be aware of, things to be cognizant of that may happen, that may most likely not happen, but just to keep in your back pocket to know that is a possibility, and some simplifying strategies, some things to help navigate the administration process, some strategies that can help you mitigate tension between family members, can help mitigate court. There's a lot of different things that we'll kind of touch on. Again, these kind of 6 topic ranges are extremely complicated and complex. So I'm going to be kind of approaching this from more of a general standpoint. I will provide some examples here and there. I will talk about some specifics to give a little bit more clarity. But for brevity purposes, and so that this webinar is approximately an hour in length, and not 10 hours in length, I'm going to kind of keep it at a minimum. Of course, we can always schedule meetings after this should you have more information for your particular matter. Absolutely happy to go through that. If you have something regarding an estate planning question, I'll kind of go through exactly the avenue and the procedure to set up an estate planning meeting to discuss any changes that you want to make with an estate planning attorney and so on. But again, I just wanted to kind of preface that we are going to be kind of talking about things from a general standpoint. Each one of these aspects could probably be its own webinar in and of itself. But again, I'll try to provide some examples and some basically illuminate the experience that I have and some of the attorneys I've had here to provide you with some foundations. Okay. So first, we're going to start with responsibility and grief, right? This is, again, a very wide sweeping topic, but really kind of the immediate impact of what happens after you've lost a loved one, whether that's a spouse, child, a parent, grandparent, a friend, you name it, right? There is deep sorrow and an overwhelming sense of loss, grief can run deep and tensions can escalate among the grieving spouse and family, or among the siblings, or among the children. I mean, and this could be that, the second parent has passed away and there are four kids. It could be that a spouse of one of the kids is creating tension between the siblings, right? There's all different iterations of this. It could be that it's not an individual that's creating tension. It could be that there is at the IRS or the California Franchise Tax Board, or the Department of Healthcare Services, someone who is or a creditor, someone who is trying to collect money, or someone who is trying to enforce deadlines. It could be the financial institution who's holding a reverse mortgage, right? And they're constantly peppering the heirs, saying that they want that reverse mortgage to be paid immediately, right? And you don't have access to the funds yet, whether it's a probate or trust, right? There's a lot of different things that come into play that can be causing tension and escalating issues that should normally not be should not be present, right? And what's also very important is that everyone grieves differently, right? Some distance themselves, while some want to get out. I've had it where I've had surviving spouses literally the next day book an appointment with myself to go over the administration, right? Some are task oriented and want to kind of have a distraction. So they come in the next day, they try to get this process going because it's a distraction for them, so that they're not focusing solely on the loss of their spouse or the loss of a child or a parent. Some will delay for a very long time because their grieving process is a lot longer, and they don't have the capacity necessarily to do everything that is necessary. So there's like I said, there's so many different iterations of this, and so many people grieve differently. I'm going to talk about this a little bit further, but I'll briefly mention it now. The grieving process can also be a point of contention. If you are the child, your parent has passed away, and you're the named trustee, and you are the one managing the estate, your way of handling grief may be different than your siblings. And your siblings may be handling it in a way, because you are not communicating on that same wavelength, that may cause some constraints. So we'll kind of go through the common pitfalls later at the end, and some things to be aware of, some strategies to approach to help, at least attempt to help to mitigate any potential issues or points of contention that we can hopefully dispel. Right. The one of the main points of an administration, well, regardless of, I'll take a step back, regardless of assets, regardless of an administration, right? You as a family member want to honor your loved one's wishes, right? Regardless of what those are. It could not have to do with the estate itself. It could be a desire for your loved one to have your remains cremated and spread at a certain place, right? That would be a part of honoring your loved one's wishes, while also trying to satisfy what others may want for that individual. So that can be very difficult. That can be very complex. Like I said, there are legal, so that's just more of a realistic, practical standpoint of the difficulties, right? There are also legal complications and complexities, like having to deal with a probate or trust administration, all of which can feel overwhelming. So as we go through this, you'll see a lot of the benefits of a trust administration versus a probate administration, but that does not mean by any means that a trust administration still isn't complex. It doesn't mean that it's not overwhelming. It doesn't mean that you won't feel stressful or anxious. So we'll kind of go through that. We'll walk through that. And I'll provide some examples of some things to help reduce anxiety, help reduce the stress. It can be a collaborative effort with you and an attorney's office, our firm. It could be a collaborative with you and your family members. There's a lot of things you can do, and there's a lot of aspects and pointers that we can provide that'll help you kind of alleviate some of those concerns. We will ultimately never be able to, yourself and myself and the firm and anyone will not be able to completely take away the aspects that are difficult, but we try to do the best that we can. Planning ahead and knowing the process can alleviate some of those frustration. Having a good estate plan in place, having a power of attorney that says what you want to be done, having advanced healthcare directive, having a trust that is properly done, that is updated to reflect current desires, can save a tremendous amount of heartache and expense in the future. A lot of times I see people do an estate plan. It's great. It's properly done. And then they sit on it for 20 years. They never review it. They never meet with the attorney to talk about any life changes. And then ultimately, 20 years later, every trustee that they've named has passed away. The beneficiaries have children. Some of those children have special needs, or the beneficiaries are on disability, right? And there's all these iterations. And now this estate plan really isn't that beneficial to the heirs because of all the changes. So planning ahead also means and includes reviewing your estate plan, right? Every 3 to 4 years, at a minimum, every 3 to 4 years, you, yourself, and your family should be sitting down, reviewing your documents, looking at it. Are these still appropriate? Is it still what I want? Are these still the people that I want to be involved? Are these still the beneficiaries that I want? If the answer is yes to all of that, it's still okay. Now let's look at what life events have transpired. My minor child is now 30. They have a PhD. They are completely self-sufficient, and they have a lot of financial acumen. Maybe we tailor their distributions to fit that. And maybe you have another child who's also 30, but not financially responsible. That doesn't have, it lacks a lot of additional formal education, so on and so forth. So maybe you need to tailor some of those things. Again, maybe there's maybe there's a daughter or son-in-law that you don't necessarily get along with. So now the conversation we need to be protecting that individual. So again, at least every 3 to 4 years at a minimum, review it yourself. I suggest meeting with an attorney every 3 to 4 years to sit down and go over it. Whenever there's a life event, a major life, a birth, a death, a marriage, a graduation, moving out of state, moving out of the country, right? Anything that you can think of that could possibly affect these documents, you should just be reviewing them or meeting with an attorney to at least discuss what potential ramifications there are. And that will save, I can't stress this enough, how much untold that will mitigate issues in the future, both from a stress standpoint, anxiety standpoint, cost and expense standpoint, and just keeping the relationships between the family members strong. Okay, we're going to kind of move into the next phase of the webinar here, looking at understanding trust. Okay. What happens next? What happens when a loved one passes away? Okay, some of the main questions are, who is the trustee, right? What are their roles? Who is or are the beneficiary or beneficiaries, and what is their involvement going to look like? Okay, so those are some main questions. We're going to kind of flesh those out as we kind of go through this portion of the webinar. So EA is, when I say EA, that's just an abbreviation for estate administration. Okay, estate administration is the process, both judicial and non-judicial, of handling the state of another. Okay. Judicial just means that is a court administration. Non-judicial means no court, right? It's a non-court administration. Most trust administrations are non-judicial, right? They're not done under the purview of a court. Now, some of them are, and there's times where we have to get the court involved, and there's times where a trustee wants the court involved or needs the court involved. But one of the main facets of a trust is privacy. Right? And a trust, if done properly and administered properly, and in the best case scenario, with the beneficiaries getting along and the trustee doing what they are supposed to be doing, the court is not involved. It is a private matter that sticks and stays within the family. Okay. Trust administration falls under EA. Probate administration also falls under EA. Okay. And I'll kind of defer the probate explanation until the probate aspect. Okay. A successor trustee is ultimately responsible for making sure trust assets are distributed according to the settler's wishes, and the primary responsibility of a successor trustee is to marshal the assets. Okay, on the previous slide, we talked about who is the trustee and what are their roles, correct? The successor trustee is somebody that you yourself or you and your spouse have named to manage your affairs when your financial affairs when you have passed away. Okay, so a lot of times what that looks like, if it's a married couple, they name, if they have adult children and they have a strong belief and faith that one of their children is a responsible person, They understand this process. They are financially savvy, right? They've named that individual as the first in line successor trustee, so that when both of the parents have become either incapacitated or both of them have passed away, this individual now steps into their place to manage the estate, right? And ultimately, the goal is to abide by what the trust says, right? You have put terms into the trust telling your loved ones and your family members what you want to happen, right? For example, you may say, I want this individual to be able to reside in my residence so long as they pay the mortgage and upkeep and property taxes, right? You can craft it however you want. I want a distribution to my children to be held in trust. They are 21, 23, and 25. Although I love them very much, they are not responsible enough and don't have enough financial education and experience out in the world on their own yet to manage their own affairs. So maybe you say, I want my friend, or I want my financial advisor, or I want my CPA, or I want a professional or corporate fiduciary to manage my child's trust fund, so to speak, until they're of a certain age, or until they have obtained enough education and experience to be able to manage themselves, okay? So that's really just the trustee abiding by the terms of the trust. And if the trustee abides by the terms of the trust, they are doing their job, right? That is one of the main things that is very significant, right? They have a duty to administer the trust. And what that means is just look at the trust terms, follow those trust terms to the best extent that they can, okay? And then finally, the primary responsibility is to marshal the assets. As a part of administration, right? That child, back to my example, let's say the eldest child is named as the first in line successor trustee. We don't know. It depends on whether or not you're sharing information with that child, okay? Let's say it's myself. My parents have shared information with me. I have a good idea of where their assets are. I understand where they're keeping track of that information. So I would most likely be able to, it's going to be a lot of work, but I would have a really good starting point, a good foundation of how to marshal. And marshal really means go update, go find, go locate the assets. A lot of times people will come in and say, hey, I have no idea where these person's assets are. You know, we have a schedule that's attached to a trust, but this trust was done in 1996. None of these assets exist. These banks don't exist, right? These banks were closed down or they were bought out. These account numbers aren't there anymore. Maybe my parents have closed these accounts and opened up new accounts, right? So marshaling the assets is a very significant and time-consuming aspect of an administration, because one has to go find and locate the assets, has to find how title is held, has to find if there's beneficiaries on it, has to find an update title if necessary. So there's a lot that goes on to marshaling the assets, and this is really a significant aspect of an administration, regardless of whether it's a trust or probate. This is something that has to be done, and typically it's the duty of the successor trustee to handle that. Okay, continuing with understanding trusts, these are some of the legal actions that have to be done. So this doesn't really matter. You could be a surviving spouse, you could be a surviving child, you could be a friend, you could be a more distant relative, you could be a corporate fiduciary. Whoever is named as a successor trustee is going to be handling these aspects. And hopefully they're handling them with an attorney's office, because a lot of these particular items that are on this page have certain legal ramifications. So we want these to be done mainly by an attorney's office. That doesn't mean that the successor trustee is not involved. Successor trustee is reviewing these documents, signing these documents. They are significantly involved in this process, but this part, a lot of these are legal requirements that must happen in a trust administration. So the first, I'll kind of go through the bullet points here, is updating the land records, right? If you own real property in California, okay, if the property was, when you created your trust, what should have happened is, if you own real property, right, you should transfer the title from you into your trust, and the trust should be the owner of that property, okay? What happens is, though, if I'm the trustee of my trust while I'm living and I pass away, right, my successor trustee needs to get on title. Why? Well, one, if they're going to be selling the property, they need to get on title so that they have the authority to sell, right? They become as trustee, they're the owner, right? They're not individually the owner, just in their capacity as trustee, okay? So I want to clarify that, because I have had clients with some confusion on that. They're just doing it in a fiduciary capacity. They're just going on as a trustee. It'll say their name as trustee of the blank, the such and such person trust. Okay. That gives them the ability to sell it. It gives them the ability to continue, if it's a rental property, to continue to be the owner and lease the property. And it also gives them the ability to, if ultimately the family decides that one or more people are going to be keeping the property, they will be able to sign that deed to distribute the property from the trust to those individuals. Okay. And to do that, we have to record documents with the county recorder that the property is located in. Okay. Kind of along with that, there's a notice to the county assessor. What happens is when someone passes away, even if property is held and owned in a trust, we still have to notify the county assessor. We have to say that it's going through a trust, and we have to say who the beneficiaries are, and they want to know for property tax purposes. Okay, I will defer on the property tax portion of this webinar, but that's the main reason of that county assessor notice. Okay, the county assessor notice, I believe, has to be submitted within 150 days from the date of death. However, after doing this for more than a decade, I've never seen a county assessor's office enforce that requirement. I have filed these change in ownership statements years later. But if you are able to file that within the first 150 days, we want to do that. Typically, our aim is to file it much sooner than that. But there are some uncommon and more rare instances where it is filed later. And then lastly, California versus non-California real property. So we handle normally all of the California real property. For any clients who own property outside of California, we work with, and we try to, if we don't have relationships already with that state, depending on some states, we have a lot of attorneys that we already work with within that state. But for example, let's say Nevada, let's say we don't have any attorneys we know, we find a referral. If you do not already have an attorney there, we try to work with an attorney there, and they are going to be the ones who handle at least updating title, right? Updating the land records, because they're going to be the ones familiar with those specific laws of what needs to be on that document, any local notices, and any local forms that need to accompany it that we would not be aware of. So that's really going to be a collaborative effort in that particular instance where you have non-California real property. Next, sending out notices, okay? You have to send notices in certain instances to beneficiaries and heirs under basically any circumstance to the taxing authorities. And when I say taxing authorities, that's the IRS. And if you're a California resident, the California Franchise Tax Board and the Department of Healthcare Services. Okay. Excuse me. For the beneficiaries and heirs, this depends on the type of trust. Okay. In certain instances, you don't have to give any notice to beneficiaries and heirs. If it is you are a husband and wife, and you or a couple, and a married couple rather, and the first person passes away, and the trust says everything goes to my spouse, okay? Then you do not have to send notices to beneficiaries and heirs, because that surviving spouse can continue to revoke and amend that trust. If it is what we call an AB or an ABC trust, then certain notices have to go out. That's just a part of California law, because portions of that trust have now become irrevocable. Okay, so just be aware that depending on your trust design will implicate and affect whether beneficiary notices have to go out. Okay, ultimately, if you are a single person, or if you are the second spouse to die, and now your successor trustee is now acting, they are required to send out this notice, and it is mandatory, okay? And there are one is required because the beneficiaries and heirs are entitled to receive it, but there are some really big benefits to send it out, because it shortens certain statute of limitations to contest a trust. The notices to the taxing authorities, that's really mainly for kind of advising the IRS and the California Franchise Tax Board, hey, my parents have passed away. I'm going to be the one filing their tax returns and signing the tax returns. Please send all correspondence to me. So that part's straightforward. The Department of Healthcare Services, that's also straightforward. If the person was receiving Medi-Cal, not Medicare or Medicaid, but Medi-Cal, we have to tell the state of California, because they may have a claim against the estate, okay? Even if they weren't receiving Medi-Cal, we still send this notice. Why? Because we say this individual was not receiving Medi-Cal, and there's no probate being opened. Please send us a letter saying the state does not have a claim. You just put that in your records, and you move forward. Okay. Lastly, lodging the last will. I can't tell you how many times clients have issues with me when I say we need to lodge the last will and testament. Remember, the trust is what's important, okay? This is kind of an outdated law, but it's still current law. So we have to lodge the last will with the county court. That does not mean we're opening a probate, just means we're lodging the last will with the court. They give you a safekeeping receipt. And then you hold on to that for your records. If you ever needed to open up a probate for some reason, then that will's already been lodged with the court. So it actually saves you a step. Obtaining a taxpayer identification number. In certain instances, in my example, both my parents have passed away. I can no longer use their social security numbers. So I have to go get a taxpayer identification number for the trust. It's essentially a social security number for the trust. I'm going to open up an account in the name of the trust. I'm going to use that taxpayer identification number, and I'm going to use that from the date of death onward until I make those final distributions. Taxes. So as you can see, I've put 6 different tax designations on here. This is for every trust administration. Anyone that comes and meets with me, and if you've met with me before, you know this, we went through all 6 of these, okay? That doesn't mean all 6 are going to necessarily apply, but we will talk about it at least, and in this webinar, each one of these can be a fleshed out separate webinar. I'm going to just briefly talk about each one. Personal income tax returns, right? And both of in my example, again, let's say it's my first parent has already passed away. My second parent has now passed away. I need to file their final individual tax return. So if they passed away in 2024, let's say sometime in June, right? They potentially earned income from January to June, right? So I need to file their final 540, 1040 personal income tax returns due the following year, as your normal tax return due date would be for you, myself, and now for my parents, okay? That part's usually straightforward. Fiduciary income tax returns. So fiduciary income tax return would be a trust income tax return or a probate estate income tax return. Okay. Fiduciary meaning that you were filing it as a trustee or you're filing it as an administrator or executor of a probate estate. This is from the date of death and onward. Right? Go back to my example. My second parent has passed away in June of 2024. I now need to file a trust income tax return from June or July of 2024 until final distribution. Okay. And there are various strategies that we can utilize to make it so that we are minimizing taxes on that trust income tax return or completely negating them in their entirety. And there's also strategies on how to delay the filing of that return and delay having to pay any tax liability. That will be something, again, you should be talking with us about. You should also be talking to your CPA about that as well. And we kind of work together. Federal estate tax returns, okay? Not to be confused with a probate estate income tax return. A federal estate tax return is probably what you've heard of more of as like an inheritance or a death tax, inheritance tax return, right? What money do you have to pay on your inheritance when you receive it, okay? Now, a lot of matters do not have to file this type of return and do not have to pay this tax because the exemption amounts are so high. Currently in 2025, I believe it was increased. I think it's 13.9 million per person. So in an instance where you're a single person and you've passed away in 2025, that individual has 13.9 million of federal estate tax exemption. So basically, if their estate is under 14 million, then their heirs do not have to file this return and they don't have to pay this return. So we will have a discussion about this with your attorney, but you may not even have to worry about it, okay? Estate tax portability election. So this is really, this is only for surviving spouses. Only surviving spouses can file this portability election. It can be a huge benefit to them. Like we talked about, that 14 million, if their spouse dies this year, their spouse has 13.9 million. But what happens if their estate, the total joint estate is only 3 million, right? Whereas a ton of exemption here that's going to be unused. Surviving spouse can file this election to capture that unused amount and put it in their own estate. And there's a lot of reasons why you'd want to put it in your own estate, because this is a law that's ever changing. Congress can change it, the president can change it. Really just depends on who's in office. So it's a something that we can't really forecast. Of course, we can try to come up with our best guess depending on who's in office, what their policies are, and so on and so forth. Okay, but that's a conversation you should have with an attorney and with the CPA. Income tax basis. This is extremely important for whether it's a spouse, whether it's a child, a relative beneficiaries, friend beneficiaries, whether it's an entity, right? There are huge benefits when someone passes away for what's called a step-up income tax basis. Okay, the best example I use is if I pass away as assuming I'm not married, I'm single in this instance, and I pass away. I bought my house for 100,000. It is now worth 1 million, right? My income tax base is 100,000. So if I was living and I sold that house for 1 million, I'd have $900,000 worth of profit. That gets taxed. The IRS says, hey, we want to tax you for capital gains tax purposes, right? But now I've passed away. My heirs are going to get what's called a date of death appraisal. And now let's say that date of death appraisal as of January 6th, January 7th, 2025 says my property is worth 1 million and they sell that property for 1 million. Now the calculation is 1 million minus 1 million. That's $0 profit. So that potentially just saved our heirs hundreds of thousands of dollars in capital gains tax. So income tax is very important. We prepare what's called an inventory of the assets. All of the date of death values go on there, and that also functions as a new basis schedule for the heirs. This is done for a surviving spouse. This is done for, again, it doesn't really matter who it is. This is a very important aspect of it, of a trust administration process. And then lastly, property taxes. If you're a spouse and it's California real property, you're going to qualify for an interspousal transfer. What that means is property taxes will remain the same, okay? If you pass away after I believe it's February 15th of 2021, you are subject to Prop 19. So if you are a non-spouse, just anticipate that that property is going to get reassessed as of the date of death. Okay, there are some very minor exceptions and exclusions to that. I'm not going to go into that for the purposes of this conversation, but just know that you should at least anticipate a reassessment to that actual date of death. So the assessors, and by the way, another thing that comes up, I think this is a good example. We talked about you getting an appraisal to reset your income cost basis. That's a private appraisal. The assessor does not look at that. The assessor will do its own appraisal of the property. It could be very similar to the private appraisal. It could be different, okay? So there are times when the county assessor will assess the property. You know, let's say our private appraisal says 1 million and the county assessor comes back and says 2 million. 2 million, right? And you go, wow, that's quite a discrepancy. At that point, you have a conversation with us, you have a conversation with your CPA, and we decide whether or not you want to challenge the assessor on their valuation. But again, that's for property tax purposes, right? Your annual property tax. Again, so just be aware of Prop 19, be aware that there is most likely going to be a reassessment for any non-spouse beneficiaries, okay? How title is held is eminently important, okay? This trust administration that we talked about covers trust assets. Now, the trustee is still required to marshal these other assets, find out who's on title, and initiate certain things. But there's going to be different actions for different things. For trust assets, you know, you're going to be marshaling them. You're going to be doing what's necessary based on the terms of the trust. But for other types of title, how actual title is held will dictate what you have to do. And a really good example of this is people will say, well, Mark, you know, my parents' trust had a Schedule A of assets and it listed 10 different bank accounts. All of these assets were listed on here. And they say, isn't that how the title is held? And I say, no, that is a good starting point to tell the people who created the trust and their successor trustees what assets there are and where to look. That is not actual title to itself, right? For real property, it's the deed that transfers it to the trust. For a bank account, you have to go into your bank account and actually retitle the account so that when you're getting your account statements, it literally says, you know, Mark O'Brien, trustee of the Mark O'Brien Trust, right? If it says Mark O'Brien and has no mention of my trust on that statement or at the bank, it's not titled in my trust. Okay, and that's what sole ownership is. My bank account at Bank of America, if it just says Mark O'Brien, I own that in my name, and that is sole ownership. Okay, and things that are owned solely are subject to probate. That doesn't, now when I say that caveat, doesn't mean you have to go probate it. Talk to us. We'll walk you through a different mechanism. There's abbreviated and summary procedures to obtain accounts in some instances. So it's not that you have to, you know, automatically have to go to probate, but that'll be something that you have to have some dialogue with us, and it's very common. Joint tenancy. If any one of you owns an account with me as joint tenants, and that's not inside the trust, it just says your name and my name. If either one of us pass away, it automatically transfers to the surviving joint account. So if you have a joint account with your spouse and one of you pass away, it automatically transfers to the other, okay? If you have a joint account with a child, or somebody else, it automatically passes to them when you pass away. So that is a very easy way to transfer assets, but it can cause a lot of problems. Okay. One, what happens if both of you pass away? Now that becomes a probate asset. What happens if one of you passes away and the other becomes incapacitated? No one has the ability to access it without a proper estate plan. Um, if it's real property, there's basis issues in holding it as joint tenancy rather than as community property if you're married. Okay, so just be aware that you have to have this conversation with your estate planning attorney so that they can properly advise you. If you do not tell them, they cannot properly advise you. Community property versus separate property. This is not really this is not necessarily how title is held. It's really how the characterization of the property. Is it community? Is it part of your community marital estate, or is it separate property? If you're a single person, you don't have to worry about this. If you are married, this is important. You need to disclose this to your estate planning attorney. You need to let them know if your entire estate is community property, if either of you have separate property, and how you want to go about treating the different designations of the community for separate. Again, that's a much more complicated topic. I'm not going to go into too much detail in that regard. Transfer or payable on death. So if I have an account, I currently have an account at Bank of America that has a payable on death to my spouse. When I pass away, all she has to do is give them a death certificate and it'll be transferred to her. Okay. Again, this is an easy way to transfer assets and avoiding probate. However, it can cause a lot of problems, right? If I'm incapacitated, who can access the account? No one can. A lot of issues. Two, what happens if my spouse predeceases me? Where do these funds go? Have I named out mine? Do I have backup beneficiaries? Have I named minor children? Have I named people that are qualifying for special needs or supplemental needs? Have I named people that are qualifying for disability? Did I just disqualify them by naming them as outright beneficiaries on these TOD or POD accounts? So again, have this conversation with your estate planning attorney. Without having this conversation, they can't properly advise you on how to structure these things, okay? Revocable living trust, that's titling the actual trust for the accounts. So whether that's deeding a property into your trust when you create the estate plan, as part of the trust administration, we would help you update title. We talked about that a little bit before in a prior slide. Same thing with the accounts. If they're properly titled in the name of the trust, your successor trustee will go marshal those accounts. If you have 10 different accounts at 10 different institutions, and you've passed away, your successor trustee will go locate all of those, and then they will start condensing, right? They will start closing out the accounts. Hopefully, depending on the amount of the accounts, let's say it's $1 million total, right? Then they would be looking at FDIC insurance limits, be making sure that there's no issues, should there be an issue with that bank, making sure we're under those limits, but trying to consolidate so that the expenses are being paid out of one or two accounts. This makes it much more easier for the trustee. And should they need to require and give information to the beneficiaries, right? It's easier to provide bank statements. It's easier to do a trust accounting and so on and so forth. It's also easier for the trust income tax return. So it's easier for your CPA. So there's a lot of different parts that moving parts that kind of go into that. Beneficiary designations. Similar to a TOD, POD scenario, beneficiary designations most of the time come up with a life insurance policy or a retirement plan, okay? A retirement plan, such as an IRA, cannot be named in the trust, right? It's called an individual retirement account, okay? So that means it has to be in my name as an individual. Now, I can name a trust as a beneficiary, or I can name my spouse, or I can name my kids, or I can name a charity as the beneficiary. But again, have this discussion with your financial advisor, have this discussion with your CPA, have this discussion with your CPA, your estate planning attorney, so that these things can be done appropriately based on your circumstances. And again, you're reviewing not only your estate plan, every 3 to 4 years, but you're reviewing your retirement assets, your financial plan, your beneficiary designations to make sure everything is still appropriate based on your circumstances and based on what the current law is at that time. LLC, right? So this is a business entity typically done to help run businesses. It provides asset protection, creditor protection, bankruptcy protection, potentially spousal protection. But normally, if assets are titled in the LLC, then you don't need to change anything. In certain instances, sometimes you just need to change the underlying private documents like the LLC operating agreement to reflect that there's a change in a membership ownership. I won't go into too much detail into that. Talk with us, talk with your business attorney. We'll work together on making sure that is updated appropriately. really the kind of the biggest takeaways, if you're doing an estate plan and you have an LLC, right? You need to, and you own a portion or all of the LLC. It's typically in your name, or you and your spouse's name, or you and your family's name, right? You need to transfer your portion into your trust, and our firm can help you do that. If there's an administration that's occurring, we will also help you update that membership ownership information to reflect the beneficiaries, or if it's a spouse and you're dividing into subtrusts, we will help you and guide you through that. Corporate partnership ownership, same concept as LLC. Those are just different types of entities. Again, we will help you walk through updating title to that as part of the administration or as a part of the estate planning process. Custodial accounts, the UTMA, that's Uniform Transfer to Minors Act. This can happen in a trust administration. This can happen in a probate administration or a conservatorship or guardianship. It just happens, an account is placed in for a minor child, of which it's called a custodial account because there's a custodian managing it, right? Such as a parent or some other family member, or even maybe potentially a court-appointed person, okay? Type of trust assets. We kind of started briefly talking about this. There's financial accounts, there's retirement accounts, there's real estate, life insurance policies, business interests, personal property. Personal property could be vehicles. It could be a mobile home that's not attached to land. It could be a boat. It could be your furniture, furnishings, clothing, right? That's really what encompasses a personal property. And digital assets. Digital assets could be social media. It could be cryptocurrency. It could be banks. There are non-brick and mortar banks that only operate online. They're almost like an e-bank, right? That could be a digital asset. There's intellectual property that could be deemed as a digital asset. You could own the domain name to a website. So there's a lot of digital assets. And all of these different things. You have to be talking to your estate planning attorney. You have to be talking to your financial planner and your CPA to make sure that they're titled appropriate, that they match your desires, they match current law. And then when you come in for an administration, how each one is titled will depend on what advice we give you, right? If a retirement plan names individuals outright, then we will help you start that process so that those individuals can claim, right? If it names the retirement plan, the IRA names the trust as a beneficiary, we will instruct the successor trustee how to get that process started, how to update title, and how to start flowing that out to the appropriate individuals. Same thing with life insurance, same thing with business interests, depending on how title is held, depending on the other owners, depending on what the trust says, right? That will all come into play. That will all be a part of the process, and we will assist and walk you through that. Okay. This is really more of just a kind of overview of a lot of what main assets exist in a lot of people's estate plans and their estates. Okay. Now I'm going to kind of transition to understanding probate. There's going to be a little bit of overlap, as you'll see, but there are some significant differences. Okay. Probate is a legal process that happens after someone dies. Probate is the same for trust administration. Okay. It is just a process to transfer assets from the individual who owned the asset to the heirs. Okay. It's just how that process works and what has to transpire during that process, who oversees that process, and what the little different nuances are that are the differences between the two. Okay. Probate involves managing the deceased person's estate, their belongings, their money, their properties, and making sure everything is distributed according to their wishes or state laws. The reason why it says to their wishes or state laws, if you have a trust, it's properly funded, you will, in most instances, you will avoid probate. If you do not have a trust, you may have a will. Okay, some people have a will and they don't have a trust. A will still has to be probated, but a will still dictate all of your wishes. So that will gets admitted, assuming it's a valid will, a valid lawful will. We submit that to the court. It gets entered to the court. The probate still has to occur. If someone does not have a will, so they have nothing, we call that intestate. That's just a fancy term for this person did not have any documents when they passed away. The state of California has an estate plan for you. Okay, there are code sections in the California Probate Code that say if you pass away without an estate plan, this is how your estate plan, this is how your property and assets, this is who they go to, and this is what that looks like. Okay, so everyone, even if everyone who's 18 or older and is a resident of California, the state has created an estate plan for you, no matter what. Now, you may not like that estate plan, so that's the reason why you want to create a trust. And that estate plan, again, may not fit what you need. If you have a special needs child and you have $1 million estate and you pass away and you don't have anything, and that ultimately this $1 million goes to the special needs kid, did you just did you, by this transfer, it goes to them outright? Did you just disqualify them for all their state and federal benefits because of a lack of planning, right? And you can see how all of this transpires. There's creditor protection involved in certain ways of planning. Does your child run a business, or are they involved in a profession that has high liability, high risk for lawsuit, right? Are we trying to plan for that so we can try to protect those assets? Okay, probate doesn't do any of that. So again, probate similar as far as we are transferring the assets from one person to their heirs, but what's involved in the benefits and pros and cons are quite different. Okay, initiation of a probate. After someone passes away, the first step is to file a petition in court, start the probate process, right? Who files? Usually the executor named in a will or an interested party. So if the person had a will, most of the time that will is going to say, I name this person as my executor. Okay, and that executor, similar to a trustee, it is a person who is appointed to manage your affairs, right? When it says interested party, that is for someone who does not have a will, right? I pass away, I don't have a will. The state of California says, okay, here is a list of individuals who have the right to file this petition, okay? And it'll order the list in order of priority. So it'll say spouse, right? Then adult children. Then if you don't have either of those, then potentially grandchildren if they're adults and domiciled in California. If you don't have any of those, your parents. If you don't have parents, your siblings, right? The list goes on and on and on to find someone eventually who can file this petition. Okay. A creditor can also file this petition if there's nobody there, or if they are trying to pursue a claim against the estate. Typically, what that looks like is you file the petition with the accompanying documents, and then a hearing is set. And what will happen is you have to give notice to all of these people, the family members, any interested parties. You have to publish the petition in a local newspaper. All of these people have the ability to show up on the date of the hearing. They have the ability to submit objections either to the probate itself or to your appointment. Assuming there are no objections, assuming everything goes smoothly, the court will verify and approve and enter the will into the probate, and also verify and approve the appointment of the executor or the administrator. A general term for that is personal representative of that probate. Okay, and that's just to start the probate. So you can see there's a downside here because you have to file that petition for probate, and then a hearing gets set. And then what happens if your hearing doesn't get approved and it gets continued, right? It could be that you don't have any access to assets or information for at a minimum 2 months up to 6 months or more. And what happens if someone objects, or someone files a competing petition, or says that you're not an appropriate person to administrate? You can see how this downhill snowball effect that can happen. And what if this person had real property, and there's mortgages and there's expenses, and you don't have access to pay for any of this? That means you have to either come out of pocket or get a loan to float you while you were trying to get access for this, okay? And now all of the stress that you had just times 10, times 100, right? And potentially you have the beneficiaries also barking at you, where are my funds? Where are my assets? And you don't even have control yet because of this court process, okay? So that's one of the pitfalls and one of the common strategies I'll discuss a little bit as we kind of move along here. As a part of the probate process, just like with trust administration, you have to inventory the assets. You have to marshal the assets, okay? The difference is in a trust administration, that inventory is really only for you and the beneficiaries. The inventory in a probate, however, is a little different. We have to file this inventory with the court. Anything filed with the court is public record. So that means creditors can look up and do a court case number search and look up to see the inventory of his decedent, and they go, oh, wow, look at those assets. I'm going to file a creditor claim. Or they'll look up to see who the beneficiaries are. And if you have creditors or some judgments against you, they will keep track of that. And the second you get that, they may be filing liens or trying to subpoena you to court to pay off a prior judgment, okay? Whether that's a spousal or a child or a business judgment or a lawsuit or, whatever the case is, okay? So there's some significant downsides here. Further, in an inventory with the probate, the personal representative usually values the cash assets themselves, and then the court will appoint what's called a California probate referee. That's a fancy term for an appraiser. They will value all of the non-cash assets. So that's personal property, real estate, securities, annuities, you name it. Anything that's basically non-cash, they end up appraising. They fill it out and they send it back to you, and then you file that with the court, okay? Laws of probate. So there are numerous aspects of different areas of the law that apply to a probate. So kind of obviously the California Probate Code, there's something called the California Rules of Court that we also must be aware of. Each county has their own local rules and additional requirements and additional things that you have to be aware of. Policies of court, that's, I'll kind of forego that part, not too important for this discussion. California family law, family code sections, there are some family code sections when dealing with probate that we have to be aware of. And then the California Code of Civil Procedure, that is more for the attorneys. But again, all of these different areas of the law that come into fruition when handling a probate. Also not on this slide, if there's a business, you may have to deal with the Business and Professions Code. You may have to deal with the Corporations Code. You may have to deal with the Health and Safety Code. There are a lot of different laws that come into play. Now, some of them may not. You may pass away, and all this, your loved one may pass away, and all they had was a $1 million bank account, right? And they had no creditors. The heirs are getting along. Sometimes some of these things are relaxed or really not important. They may be irrelevant, but again, you're talking to the attorneys regarding this, and they'll kind of guide you through which of these we have to be aware of and why. Probate code, the main code section of the California law that we'd have to be abiding by for every single probate administration. The probate code is very specific, requiring adherence to set timelines, hearings, and notices, which most often result in lengthy and expensive court processes. Okay. You could be doing everything perfect. You could be doing absolutely everything you're supposed to be doing under probate administration. But the court could mess something up. The court could fail to review something on time, and then they will automatically kick a continuance. So let's say you file that initial petition, it's set 6 weeks out, okay? You've done everything, you've cleared probate notes, you've published, there are no objections, you show up on the day, usually our office shows up on your behalf. We show up on the day of the hearing, we're ready to approve, and the court didn't review something, and the judge is unwilling to clear it from the bench. And they go, okay, we're going to continue it. And they go to their calendar. Let's say you filed today and your hearing is the middle of February. We show up in February and they go, okay, our calendar's booked. We're way behind. We're going to continue this 4 months. And now we're in June or July and you still haven't been appointed, even though you have done everything appropriately and we have done everything appropriately. And now, right, creditors may not be happy. The other beneficiaries and heirs and family members may not be happy. You're not going to be happy. We're not going to be happy. But again, probate is subject to the court, right? They're the ones ultimately in control. So we are subject to their timelines, to their hearing dates, to their rules, to basically everything that they want and need, we have to abide by. In a trust administration, yes, you have to follow the terms of the trust, but some of these things are relaxed. You have more control over this. You can do things quicker. You can do things with a little bit more input of the beneficiaries. There's a lot more flexibility. Okay, moving along, the main two functions of a probate administration are the settling of the decedent's estate and the process of transferring the decedent's assets to the persons or institutions entitled to receive them. Again, this part very similar to a trust, right? The goal of the personal representative, right, the executor or the administrator of a probate is to ultimately get the assets from the decedent to the heirs, okay? That part does not change. So in some aspects, I don't mind a probate because ultimately it does its function. It gets the assets from the decedent to the heirs. It's just what does that process look like? What's the timeline? What are the cost and expense of it? What's the increased anxiety and stress level? So on and so forth. Some additional aspects for the probate. Some major steps include collection of assets, payment of debts and taxes, distribution of decedent's property. Collection of assets, so we kind of talked about that. That's marshaling the assets. That's going and finding all of the assets. A lot of times if it's a probate, someone did not have a will. So you have no idea where the assets are. So one of the main questions is, wow, Mark, where do we even look? It's like, okay, well, you got to check their mail. Right? We got to check their last tax return, right? Because they should be receiving 1099s for income from assets that, whether it's a financial investment account, some CDs, a checking or savings that's earning interest, whatever the case may be, they should be getting tax forms. We should look at the tax. We should be looking at their mail. We should be contacting their CPA and their financial advisor, right? You do a lot of this work. You should be checking unclaimed property. An unclaimed property division for the state of California or any other state that they resided in, right? There's a whole process that goes into it. And this can be a very arduous process if the person has not told you anything about their affairs. If you're coming this at basically the 11th hour, once they've passed away and you've had no communication with them, they did not keep records. They don't have any place of where this would be. You've checked the laptop, you've checked phone, you've checked mail, and there's nothing there, right? This can become a daunting process. So a trust administration typically is easier in this regard because there's a lot more involvement and effort put in on the planning side to make this transition easier, okay? The payments of debts and taxes, very similar to a trust administration. The one main caveat being there are additional notices to government agencies under a probate, and you have to give what's called a notice to creditors in a probate. You have to give notice to any known and reasonably known creditors and give them a period of time to submit creditor claims. You do not have to do this in a trust administration, okay? And that is a big difference, okay? So keeping this more private and keeping the information away from creditors, a trust can help with that. It's not going to solve all of that, but it'll help significantly, okay? The probate process and timeline, the legal process, probates on average, I would say 12 to 24 months, okay? Like I said, controls with the court, not the family. So even if you're doing everything appropriate, even if the attorneys are doing everything appropriate, the court has the final say on everything. Okay. Fees are done differently. For conservatorship administration, those are done hourly, billed hourly from an attorney perspective, but they are approved at the end of that conservatorship or at the end of the accounting period. For a probate, they're statutory. So probate is a very weird fee schedule in California, okay? We are not billed on a flat fee, so it's not like you give us $3,000 up front and we do it and that's all said and done. It's not billed hourly, where we bill our hourly and send you monthly invoices and you pay on a monthly invoice. It is based on California Probate Code statute, which has an actual schedule for what our fees are calculated, and it is based off the size of the estate. So it'll say, based on this type size of estate, you get this much as attorney's fees. If it's this size, you get this much, so on and so forth. And it's this schedule that is determined by the state of California. A lot of times, because of that, let's say you have a $2 million real property, and that was it. Someone passed away, all they had was $2 million property, no other assets are part of this probate, or they didn't have any other assets, okay? That $2 million property is automatically going to result in, just doing quick math in my head, at a minimum about over 30, about $37,000 in attorney's fees. That is not that $37,000 in attorney's fees for basically administering one asset. You have to be subject to the court control. There are additional $2,000 to $3,000 in court costs, and then any other debts that come up. So you can see how that can balloon very quickly and very easily, and it's unnecessary. Okay. There's probate notices. So again, I talked about there are additional notices for probate that, again, you still have to send the notice to the county assessor. You may have to update title. You have to send notice to beneficiaries of this probate. There's no it doesn't matter, like what I said, that certain types of trusts, you may not have to send notices. Any probate has to go to certain family members and certain heirs, no matter what, okay? Has to go to the federal and state taxing authorities. What that means is the California Franchise Tax Board, Department of Healthcare Services, notice to the IRS, right? Notice to the county assessor. At a minimum, there's some individuals, some government entities that have to go out. Sometimes you have to notice the public defender, public guardian's office. Sometimes you have to notice the county regional center. Sometimes you have to notify child or adult protective services, right? There's some other parties, depending on your particular circumstance, that you may have to notify, okay? And again, the more parties you notify, the more chances there are for issues. Some key documents. So now I'm going to kind of transition into the part of the webinar. This is more of like, okay, what things can kind of help me stay organized? What can help me kind of negate some potential issues in the future? And what are some of those strategies to try to look out for? So key documents. You're definitely going to need the trust, the last will and testament, the death certificate, and asset documentation. So if this is a probate, it'd be the will. If they didn't have a will, then that part you disregard. Death certificate, you're going to need a death certificate regardless of probate or trust administration. You're not going to be able to do anything without that death certificate. Asset documentation. So this would be copies of deeds, copies of bank statements, whether it's checking, savings, CD, copies of the financial investment or brokerage statements, copies of retirement statements, life insurance, annuities, cryptocurrency, you name it, okay? 401k, 403, it doesn't really matter. You're going to need copies in the actual documentation that reflect how title was had, the amount of assets in there, if there's beneficiaries, if there's any issues, so on and so forth, okay? So these are very good, important documents that you will need no matter what type of administration it is. Debts and liabilities, right? Bills, loans, credit card statements, mortgage statements, reverse mortgage statements, HELOCs, credit card statements, like we said, outstanding invoices, outstanding medical bills, outstanding hospital bills, utilities, anything that you could think of regarding that particular circumstance. I'm just trying to think of the normal ones. Property tax statements, right? That can kind of give you an idea of what this person's monthly and annual expenses are. If it's a trust administration, right, you may have to be keeping track of this so that you're paying these and making sure you're staying afloat. If it's a probate administration, the same thing, you're paying and staying afloat, but you may need to report this to the court, you may need to report it to the beneficiaries. Estate tax returns. This is, like I said, like on the slideshow says, relevant for larger estates. Okay, so that's going to be for, for a couple who passes away in 2025, each of you has 13.9 million. I'm going to round up, that's 14 million. So in this instance, you'd have to have an estate, if you're a married person in 2025, your estate would need to be larger than $28 million, okay? But that's as of 2025. This law is sunsetting in 2026. This law can change at any point in the future based on Congress and who's in office and who has the control of Congress and who ultimately signs and what the society looks like and what at that time, okay? Court filings. So always be keeping track of petitions, whether it was a probate petition, whether it was a petition to clear up an ambiguity or vague language in a trust, whether it was a spousal property petition, whether it was a judgment against you for a lawsuit, whether it was a personal injury, whether it was a business lawsuit, doesn't matter what it was, whether it was a petition to determine title to an asset, whether it was an unlawful eviction, any type of court petition or application, especially for probate, keep all of those documents. Especially for those who are going to be acting after you, or if you are the one serving and filing a petition, please keep records of all of those documents for your records, okay? The court a lot of times will have those records, but they make mistakes, they lose things, they scan things into the wrong matter. You never know, so you want to keep at least an electronic copy, if not a physical copy of any court filed documents. Common pitfalls and how to avoid these, okay? Failing to locate key documents, misplaced documents, delay proceedings. This goes for probate, trust administration, conservatorship, guardianship, you name it, right? If you can't locate these documents that you need, if you're trying to report an inventory and you can't find the assets or you can't find the documents, it may cause delayed proceedings, right? You may not be able to meet that court deadline, or conversely, it's a trust administration and it's been going on for quite a period of time and the beneficiaries are getting antsy. This can cause constraints between the family members, even if it's not a court administered administration, it's a private trust administration. Again, failing to look at these can cause delays, okay? Overlooking debts and liabilities, unpaid debts and taxes may create legal issues. Sometimes people will come in and say, hey, my parent hasn't been filing a tax return for the past 4 years. Why do I need to file a final individual tax return? Well, okay, one, just because they haven't been filing doesn't mean they shouldn't have been filing, right? Yes, there are times when they don't have to file, but who knows? You don't know if they should or should not in most instances. You should file one, put it on the IRS, put it on the California Franchise Tax Board to review the file and come back, okay? That's part one. Part two, you don't know if there's outstanding tax liability from prior years where they were filing, okay? So in my example, they didn't file for the past 4 years. Maybe they did file for years prior, and there's some type of tax liability still outstanding and owed. Sending notice to the California Franchise Tax Board or having an idea of unpaid taxes will help you have an idea so that when you're doing the trust administration, when you're making final distributions, when we talk about you withholding a reserve, you can make an appropriate reserve, right? If you distribute all the assets and you hold back $1,000 reserve, but you have not appropriately accounted for debts and liabilities, how is that reserve appropriate, okay? If you have a $50,000 outstanding tax liability or all debts, attorney's fees, CPA, taxes is about 50, and you hold back 5, right? That's going to be an issue. Not that you are the only one responsible, but if you have 5 and you have $50,000 and you distribute all the assets, you will have to go claw back that $45,000 from the beneficiaries and their proportional shares. Now, as you and I know, once that money gets in those hands, that's going to be a very difficult thing to do, right? Not impossible, but almost impossible, okay? And that's going to be quite, we want to avoid that to the nth degree, okay? So having an understanding of what the debts and liabilities are is paramount. Improper asset distribution. Early asset distribution can result in legal complications. So this could be twofold. This can be someone who has hired us and wants to do preliminary distributions, or this could be someone who's just made preliminary distributions the second they got their hands on the money prior to even meeting with us, or meeting with us and just doing it anyways, okay? There are problems with doing that, because what if one of the beneficiaries is going to contest the trust? Did you just fund a lawsuit against you as trustee of that trust? Right. So that's a conversation you absolutely need to have with a state administration attorney like myself, so that we can properly strategize to make sure that if you do make preliminary distributions, the amounts are appropriate and the timing is appropriate. Okay. What happens if the trust says each share should be held in what's called a dynasty trust or a lifetime trust or descendants trust, and you just cut a check outright to this beneficiary? You just breached the terms of the trust. It says that their share is supposed to be held in trust, and you just made an outright distribution to them. That person, what if that person was a special needs person? You just cut them a check for $20,000. Was that a direct breach of the terms of their special needs trust? 99.99%. Yes, that was a breach of that terms of that trust. Okay. Someone's receiving disability benefits. You made an outright distribution of 20 grand. Did you just potentially disqualify them? Potentially. Yes. Was that a breach of the trust? Yes. So as much as we know that there are other things at play, there are family members who are in your ear trying to get you to release money, you can always say, look, I want to release the money. I need to meet with the attorneys to be advised on how this looks, on how to move forward, on how to make that distribution. And if it is appropriate, then yes, we can structure that preliminary distribution to be done appropriately, so that you are not causing any liability for yourself. You're not breaching any California laws, and so that you're not creating a lawsuit against yourself in the short or distant future. Okay. Missing deadlines. Missing court deadlines prolongs the process. Anytime you miss court deadlines, that's going to prolong the process, and that's going to cause anxiety and stress for yourself, for our attorney's office, and for the family members and heirs. This happens a lot when people try to handle the probate administration on their own. There are court deadlines that the court's not going to tell you about. You can file a probate on your own, but yes, they may set a hearing date and you may know of that, but you don't know the court deadline to file an inventory. You don't know the court deadline to file a creditor notice. You don't know the court deadline for what's called doing a spousal elective share or foregoing such. You don't know the credit for a spousal property petition. You don't know the court deadline for a creditor to contest and the next steps. There's all these deadlines that are not provided by the court that you don't want to miss, because they can result in continued deadlines. They can also result in sanctions. The court can sanction you and even a law firm for failure to do what they are required to do. Okay. And all of that just prolongs a court proceeding. Okay. Mismanaging estate funds, similar. And this mismanaging could be mixing personal and state funds. That's called commingling. If you commingle, that's a breach of both a trust and of a probate administration. That can lead to disputes, that can lead to legal consequences, that can lead, even if it wasn't, intentional, or done under the auspice of trying to gain more assets or to have more control, right? It could have just been an accident. From a beneficiary standpoint, right, it looks like you're a bad actor. It looks like you're doing things inappropriate. It looks like you don't know what you're doing. It looks like our law firm doesn't know what we're doing, right? So there's a lot of these things that we can negate by making sure you are keeping the trust account separate. You are keeping the probate account separate. You are keeping your personal funds separate, right? There is a segregation of all of these things, and you maintain that distance and that separation through the entirety of the administration, right? And when it comes time to make those final distributions, we assist and walk you through exactly how that looks. And then eventually, the goal is to close that trust account, close the probate account, and move on. So simplifying strategies, again, kind of continue from the last portion of the webinar. Create a comprehensive estate plan, right? And what that means is, and I'm going to take this one step further, not include a will, not consider a statement of trust, have a trust, okay? The will should be a backup document. Have a trust, okay? A will will not avoid probate. A will does not avoid probate. A trust avoids probate, okay? A pour-over will is absolutely necessary with the trust because it's a catch-all. Should someone forget the title, something in the trust and a probate is necessary. At the end of the probate, it'll go to the trust. But set up a trust. Comprehensive estate plan means set up powers of attorney, set up advanced healthcare directive, set up HIPAA authorization, do the portable will, do the assignments, do the deeds, look at your non-trust assets, your life insurance, your retirement plans, make sure that they coincide with your estate plan. And then again, continuously monitor his estate plan. You don't need to read it every day, every week, every month, but every couple of years, sit down and look at it. Anytime there's a major life event, birth, death, marriage, divorce, a child turned 18, child went to college, child graduated from college, so you opened a business, you closed a business. Anytime you're doing this, please review your plan, please meet with the attorney. And if you can, meet with the attorney prior to a decision you're making, okay? I can't tell you how many times people will buy a rental property and then find out about Prop 19 and find out about the protections of an LLC, and they'll come to us after they've already purchased it. And yes, we can still transfer it to LLC, but there's so many more benefits that we could have helped you with should we have formed that LLC first and had that LLC purchase the property and then make sure that the LLC membership shows your trust, right? There's always different strategies that we can do. Make sure you're contacting your estate planning attorney, setting up a meeting with them so you can go through this, okay? This avoids a lot of constraints. As I talked about earlier, again, having the comprehensive estate plan is great for probate avoidance, but if you're not constantly or at least periodically reviewing this and meeting with this and making updates to reflect appropriate desires and current scenarios and current law, having a trust at 20 years old can create just as many, if not more, problems than having no trust. Okay, so that is a very key aspect. I want to keep harping on that because it's very important. Organize key documents. I'm going to kind of skip that part. We kind of talked about organizing the key documents. Even when you're doing a probate or trust, making sure you're having tracking all costs, any reimbursements that you've reimbursed yourself for costs out of pocket, making sure you're tracking all of that, keeping receipts, whether physical or electronic, keeping track of the debts and what was paid, keeping track of what funds came out of what account. All of that is extremely important, okay? And the better record keeping you do, the easier it is to demonstrate to the heirs and beneficiaries that things are being done appropriately. Naming a reliable executor, naming a reliable trustee, okay? So a trustee on a trust administration, executor, or administrator on a probate administration, even though there's different process, they do the same function, right? Winding up a person's estate, paying the expenses, marshaling the assets, right? Naming someone who is capable and trustworthy. You want someone, so a lot of times you have to take into a lot of different things, right? If you are in your 70s and the person you trust is also in your 70s, okay, you have to be thinking, what happens if this person becomes incapacitated? What happens if they don't want to accept their role? Or what happens if, God forbid, they become deceased? Okay, you need to be thinking about, is this person appropriate? Are they geographically? Where, if I'm in California and they're in Maine, now in 2025, with things being so electronic and technology being so advanced, we can kind of do things a little bit easier for people that are out of state. But being in geographic location is also helpful, because what if there's a bunch of real properties, right? And they need to be flying out here to be handling that. Be looking at geographic location, age, whether they're wanting and desiring of having to do this role because there's a lot to do. Are you naming successor executors and trustees after that person, just in case? Are you naming people who are maybe the decade under that, or sorry, the generation under that, so that there are less complications, right? This is always something to be considering. And again, reviewing your trust every 3 to 4 years can kind of go, oh, you know what? I named these family friends. We're not really friends anymore. They're not really people that I want to name. Maybe you named a financial advisor and you've moved your portfolio and that person isn't a part of your financial plan anymore. You shouldn't be naming them. Maybe your kids were minors and now it's 15 years later and they are more than capable and you want to name them as a successor trustee or trustees, okay? So those are all things to take into mind, to think about and have an appropriate person named. Communicate your wishes clearly. Discussing your plans with the family will avoid disputes. This is complicated. I'm not going to get too far into this. I want you to talk to your estate plan attorney about your specific scenario, okay? Sometimes over communicating is very helpful. Sometimes under communicating is very helpful, okay? Depending on what your goals and desires are. It really just depends. But at least communicating with your successor trustees, telling them I've named you this. I'm telling you where at least some of my assets are, where to look to find them, or people that you can contact to go find. And communicating and keeping a lot of times people will overcomplicate their trust. Sometimes communicating their being clear and concise helps demonstrate your intent. Sometimes when things get too convoluted, it can kind of confuse what your actual intent was, okay? But again, this is something I want you to have your conversation with estate planning attorney. Goes hand in hand with consulting with professionals. Work with the probate attorney, work with the estate administration attorney to navigate the legal complexities effectively. Work with your estate planning attorney, your CPA, your financial advisor to work through your planning aspects, and that will help just make this transition easier, but not easy. Okay, like I said in the very beginning, this will never be easy. This makes things easier. It does not make it easy. And trust administration, probate administration, there's a lot going on. There's a lot of work that has to happen. I don't want to undersell. If anything, I want to overstate the amount of work that has to go into an estate administration, regardless of whether the court is involved or not. Okay. Again, we're at about hour 20 here. I could keep going on for hours and hours each one of these, and there's so many scenarios. I'm going to kind of wrap it up here today. Again, I apologize. I wanted to kind of keep it for brevity and for generality purposes. We'll probably just kind of wrap it up here. Conclusion, right? We want to simplify the legal processes. We want to resolve disputes effectively. What that means is sometimes that does mean going to court. So when I say resolve disputes effectively, sometimes going to court actually does that effect. Okay. But in most instances, as an administration attorney, you want to avoid court. You want to avoid that additional stress and potential additional expense, ensuring asset compliance and providing expert guidance, right? Those are all things that our firm, the attorneys in general, will help you with on the administration of the estate. Okay, this part I do want to harp you on. So as a part of this free consultation, you'll see at the bottom part here, it says this event qualifies you for a free consultation to review, update, and maintain your estate plan. So I'm an estate administration attorney. Like I said, I do have estate planning experience, but that's not my main role here. This qualifies you. Please contact our office for a free consultation on your estate plan. And ultimately, the best case scenario is almost what I love to hear is you made that appointment, you reviewed your documents, you and the attorneys have decided everything is up to date, everything reflects your desires and wishes, no changes need to be made because of your current circumstances or current law, and you just go on your way, right? That is best case scenario, and that's what I love to hear. Or maybe things have changed, right? And then you want to make some changes and updates, and that's going to save you, a significant time, stress, and expense down the line when an administration occurs because of that. Okay. As an aside, regardless, for my department, for state administration, regardless of whether you attended this, we automatically do a 30-minute free consultation. So if you have to meet with us for an incapacity administration or trust administration because someone's passed away, probate administration, conservatorship administration, guardianship administration, you name it, if it's an administration, we automatically give 30 minutes of that first initial consultation is free. So if you meet with me for an hour, half that hour is automatically free, okay? Just some last final facts here. About our firm. You've probably seen this on a lot of our market materials. If you're joining us today for the first time, we have 11 full-time attorneys, 1 attorney of counsel, 3 CPAs. We have over 350 years of combined experience. A lot of individuals here have advanced tax degrees. We have a couple of certified specialists in probate, estate planning, and trust law. What that means is those individuals went and took a second bar exam, a specialist bar exam. So they went and took that second exam. I believe like 1 in every 1,000 or 1 in every 10,000 are certified specialists. So that's a pretty important designation. We have over 50 plus support staff, very diverse staff and skills. We have 8 office locations, and we're always available by Zoom, but we try to do our meetings at least if we can in person. Okay, this is kind of the last page. I'm going to leave it on here for a little while. This is our phone number, our webpage, email. Please fill out the digital evaluation. Any constructive feedback, always welcomed. I do not take it as an insult. I'm always trying to convey and effectively communicate the most amount of information that I can, the max amount of information, and in a manner that is digestible. I can't tell you, even being a lawyer, there's legalese that makes things overly complicated that I don't even like to try to decode. But if there's anything that you think I didn't touch on, or any feedback that you want to provide me, or if you just want to say, hey, thank you, Mark, we appreciate it. Any and all is welcomed. I just want to keep tailoring my future webinars to help you and the rest of the clients have a better experience, extract more out of what we're talking about, so on and so forth. While I keep it on the screen, I know we're getting a little bit over here. But I believe there are some questions. I will try to look at some of the chat here to see if I can answer some of them. Some might be some might be a little bit too specific, so I'll kind of go there. Some of those, and some of them might be questions for the marketing, so I'll kind of skip through those. Okay, so it looks like Glenn asked a question where a person with Copenbarger trust owns no property in California. Is the trust finalized after death in California or the state where they now live and own property? Okay, so if you created a California trust with us, it does, and it says that the jurisdiction is California, okay? It doesn't necessarily matter where the property is located if it is titled in the trust. So if you sold your California real property and you went and bought, you moved to Idaho and you bought a residence in Idaho, but you titled it in the name of the trust that you created with us, then yes, when that person passes away, the trust is still valid. It's still done under California law. Okay. So the short answer is it depends on what happened once you got rid of that California assets. Okay. If you went to Idaho and purchased residence and you put it in your trust and you kept that California trust, it would still follow under California law. If you did not put it under the trust, then if someone passes away, that would be subject to a probate, but it would be under Idaho laws, and we would not be involved in that. You have to go find an Idaho attorney. So again, it just depends on what the client did specifically in this particular case. If it just depends on whether or not they properly titled the name of their trust. But that can be a question that, if you want, you can schedule that meeting with your estate planning attorney and make sure that that's done appropriately. Let's see, is it possible to speak louder? Oh, that's So someone asked if they're in the body donation program with UCSD, but I did this arrangement before my escrow will it affect my escrow in any way if it is not included? Okay, so if you have a trust, that's going to dictate the control of your assets. Your will most likely dictate your assets, whereas your body donation program, this is something that you probably want to be reflected in your advanced healthcare directive. So we talked about that comprehensive estate plan. Your advanced healthcare directive is like a medical power of attorney that would dictate where you want and what you want to be done with your remains. I would say do an advanced healthcare directive and then put in that advanced healthcare directive that you reflect that you are a part of the body donation program with UCSD. And now the person who is your agent knows that. Otherwise, if you don't do that, you need to be advising your medical decision-making power people that is the case. Otherwise, how would they have any idea? Also, you want your advanced healthcare director to show that, because in that instance, if they bring that advanced healthcare to a hospital or something's happening with you, right, they can put that on file and the hospital will know if they have not already been advised. Okay. Can the deceased Roth IRA continue until spouse dies, or does it need to be distributed now? If you are the surviving spouse, and the surviving spouse is named as beneficiary on that IRA, it does not matter if it's a Roth or a traditional. If the spouse is named as beneficiary, then yes, you can do what's called a spousal rollover IRA, and you just need to speak with your financial advisor and the institution to initiate that. Okay. Okay, that's it for the other questions that require too much of a specific answer. So I'm going to leave it at that. For now, again, we're going to leave it. I'll kind of go back. We're going to conclude the administration at this time. Again, thank you for joining me today. It was a pleasure speaking with you. Please feel free to leave your feedback. And again, that free consultation with the estate planning department, reach out, set that meeting. It could be that you don't do any work and everything's already done appropriately. And that is best case scenario, what I would love to hear. Okay. Otherwise, Happy New Year. Hope everyone had a great holiday. And we look forward to working with you, look forward to hearing from you. And again, it was my pleasure to be here with you today. Okay. So everyone take care. Have a nice rest of your week and God bless.